Good afternoon, everyone. My name is Omar Mohammedi. I'm an attorney practicing in New York, former commissioner, New York City Commission on Human Rights, and my practice includes mostly employment discrimination, civil rights cases that I've been involved, many of those including issues related to FOIA, as well as profiling. I have litigated various cases, including the Mohammedi Diallo case, 6 Imams case, and many other cases also related to employment discrimination cases. So now that can lead me to the next subject here, which is a Glomar response, which is an interesting theory. Glomar is a judicial theory. And Glomar derived mostly from I mean, not mostly, but all from federal cases that allows the agency to say the following: we cannot confirm or deny the existence of any records. And recognizing of such document, even if we say we have them, but we cannot produce them, it will result in injury and the Freedom of Information Act. So you can see there are some cases there that you have, but I'd like to tell you that Glomar obviously was initiated and by 2 major cases. And the first one, and they were both in DC Circuit. The first one is Filippi versus CIA, 546, Fed 2nd, 2009, DC Circuit 1976, and the other one, Military Audit Project versus Casey, 656, Fed 2nd, DC Circuit 1981. And both, they involve a request for information about secret Central Intelligence Agency program to raise a sunken Soviet submarine using a privileged registered salvage ship that's named the Glomar Explorer. The Los Angeles Times partially broke the story about the program in February 1975, prompting the CIA to attempt to suppress further reports. CIA officials convinced news outlets to refrain from further reporting on the subject for more than a month for national security. But eventually, the major news organizations ran stories both about the details of Glomar Explorer project and about CIA effort to bury the story. After news broke about the government attempt to suppress the Glomar Explorer story, Harriet Ann Filippi, a journalist, filed a FOIA request with the CIA seeking all records relating to CIA attempts to persuade any media personnel not to make public the events relating to the activities of the Glomar Explorer. Instead of responding to Filippi's request in the usual acknowledgement that response record existed, but were exempt from a release, the agency issued a novel response. It stated that the fact of existence of no existence of the record you requested was itself exempt from disclosure as a classified matter of national security. Therefore, what did they say? We cannot confirm and deny existence of such documents. Around the same time, a Filippi plaintiff in military audit project submitted the FOIA request for the CIA Department of Defense, seeking records describing the U.S. government role in the planning, designing, construction, leasing, use, and disposition of the Glomar Explorer. Both agencies responded by refusing to confirm or deny the existence of such records. The requesters of Filippi and military audit project independently filed suits to compel the government to reveal whether or not it has a responsive record, if so, to release them. So Filippi request was the first to reach decision on appeal. The CIA claimed that the very fact of whether or not it has a record responsive to Filippi was exempt from disclosure under exemption 1 and 3. And I would like to discuss this under example 1 and 3. If you remember when we were talking about FOIA exemptions, we said exemption number 1 was based on classified information related to executive order. That's exemption 1, right? And to preserve the security of interest of a nation, of the nation. And that's based on an executive order. So that was invoked under Filippi. The second exemption requires, obviously, the statute from which is an act of Congress under the US 5 US Code, section 552b3. Now, as you can see, a Glomar theory was invoked based on those major exemptions because it's a federal agency and leads to issues with national security. Now, the court held that the agency's refusal to confirm or deny the existence of a requested document was permissible under FOIA, but to reverse and remand because the district court has based its ruling solely on camera affidavit submitted by CIA without attempting to compile a public record. In approving the Glomar response, the court explained the reasoning as follows, and this is very important. In fact, the situation is as if appellant has requested been refused permission to see documents which says either yes, we have record related to contact with the media concerning the Glomar Explorer, or no, we do not have any such records. In such cases where disclosure of documents will itself compromise national security, the government could claim that national security consideration require is to refuse disclosure whether or not document exists. What does it tell you? Under Glomar, obviously now, is in order for any agency to claim we cannot confirm and deny, you cannot, no agency can claim, can recognize the existence of document and then go back and say we cannot confirm and deny the existence of document. If you recognize the existence of document, that's it. You cannot claim Glomar. Glomar, you will have to be very clearly stated that these documents were not acknowledged, the existence of such document, before you do that. If you acknowledge the existence of documents, then that's it. You cannot claim Glomar. Now, Filippi, obviously, Filippi 1, that's opened the door to new government response and FOIA requests, and there were quite a few cases that followed the Filippi. Some of them were denied, some of them were accepted by the court, and obviously Glomar response, which is a judicial theory, has been narrowly tailored also, because it's when you claim we cannot confirm and deny, what you're doing, you are actually preventing judicial review of what you're saying. Under Glomar, you cannot, as you can see here, you cannot produce documents. Once you claim Glomar, the court itself does not have a right to in-camera review, which means cannot even review those documents if what you're saying is true or not. While under a regular FOIA or FOIL, you can still, the court can still have jurisdiction in reviewing the documents when Glomar is not asserted. Then you can say, here is the document, the court will review the document and determine the validity of your argument that's about the documents, if it's valid or not, the exemption that you are requesting. Now, what I'd like to mention now, obviously, FOIA, under FOIA, many cases involve Glomar theories, and this has been used so in the section 552B, 552A, 552A, and also we'll use first one under the national security based on executive order. Second, those cases use Act of Congress. And then third, many of those cases, they involve the exemption under FOIA, which is Section 7. Now, if you notice, even when an agency claims Glomar theory, it will have to tether. It will have to tether the exemption. They have to tether the Glomar exemption to the Glomar objection to the exemptions under FOIA, which means they will have to use one of the exemption existing under FOIA to claim Glomar. For instance, Section 1 related to executive order, Section 3 relates to Act of Congress. Now, Section 7, when an agency, and mostly a law enforcement agency, was a record for information compiled for law enforcement purpose, but only to an extent that the production of such law enforcement record information will interfere with enforcement proceeding. Which means what? Which means that if that law enforcement proceeding, such as an investigation, was terminated, was done that way, no reason for the agency to claim Glomar under that theory, because there is no interfering when investigation is completed. So you can't claim that. So this is the other exemptions that Glomar theory has been used by many federal agencies. Now, under FOIL, court usually when there is an issue related to exemptions, they use New York case law usually had that court find federal case law to be instructive when construing specific state FOIL provisions that are patterned after federal FOIA provisions. Nevertheless, as I stated, under Glomar, what you can see, there were many changes under FOIL since 1974, and those changes did not really say anything about Glomar, did not say anything about, and those cases I can see, they were mostly 75, 76, and we have amendment under FOIL that were, many of amendment happened in 1977, and actually 1982, 2005, and 2008 again. So none of this amendment included an exemption to disclosure that permitted an agency to say it can neither confirm nor deny the existence of a record responsive to a request, which was mentioned in the FOIA in FOIA explanation.